Okay, I want you to imagine a complete nightmare scenario in your own home. There's a leak, and it just won't stop. Now, what if the one group that's supposed to protect your property, your homeowners association, basically tells you they can't help? Well, today we're going to break down a real-life legal fight that pulls back the curtain on the complicated and often frustrating rules that so many of us live under.
So, let's put you right in the middle of this situation. Water is seeping into your house, causing damage, and you are absolutely convinced it's coming from your neighbor's place. So who's on the hook to fix it? Is it you? Is it your neighbor? Or is it the HOA's job to jump in and sort things out? This is the exact question at the very heart of the case we're about to dive into.
And to get to the bottom of that, we need to meet the person who actually lived this nightmare, a homeowner by the name of Susan Abbass.
Can you just imagine how maddening this would be? We're talking for more than a full year. Every single time it rained, Susan had to watch water leak into her home. This wasn't some tiny little drip either. It was a serious, ongoing, damaging problem, and understandably, she was desperate to get it fixed.
And believe me, this was not a quick fix. Not even close. After putting up with the leaks for over a year, she finally filed a formal petition in May of 2020. But just look at this timeline. The first hearing wasn't until July. Then an initial ruling went against her in August, and it wasn't until late November that a final rehearing happened. This was a long, stressful, and no doubt very expensive battle.
So why the huge delay? Why did this drag out for so long? Well, that's because this whole thing created a really tricky legal dilemma for the Homeowners Association.
Okay, so this is where it gets really tense. This is the core of the conflict. On one side, you've got Miss Abbass, and she's saying, look, my house is being damaged right now. This is an emergency. You, the HOA, need to use your power and force an inspection of my neighbor's property. But on the other side, the HOA is pumping the brakes. They're worried that if they just march onto someone's property without solid proof, they could get slapped with a lawsuit for overstepping their bounds.
Now, to be fair, the HOA didn't just, sit on their hands. They did take a few steps. They reached out to the neighbor to ask for access. They even sent a warning letter about some plants they thought might be causing a problem. But they drew a hard line at forcing their way in. They argued they just didn't have enough proof, and their position got even stronger when they found out the neighbor's own insurance company had already looked into it and said their client wasn't at fault. That really muddied the waters.
And this whole case, literally the whole thing, boils down to two little words: rights versus obligation. See, the HOA's own rule book gave it the right, meaning the authority or the option, to enter someone's property if there was an emergency. But here's the key, and this changed everything. The rules did not create an obligation or a legal duty that said they had to do it. So they could act, but they weren't legally required to act.
So if the HOA wasn't forced to do anything, how in the world is a judge supposed to figure this out? Well, it all comes down to one thing: proof.
In the legal world, there's this thing called the burden of proof. And what that really means is that the responsibility fell on Miss Abbass to prove her claim. It wasn't the HOA's job to prove they were innocent. It was her job, her burden, to prove they had actually broken their own rules.
And the standard for that proof is called preponderance of the evidence. It sounds super technical, but here's what it means, straight from the legal definition. She had to provide enough proof to convince the judge that her story was more probably true than not. It's not about being 100% certain, just tipping the scales past 50%.
All right, so let's look at the final scorecard. What did Miss Abbass actually manage to prove? Well, she definitely proved a leak was coming into her house from somewhere else. She even showed that she was willing to foot the bill for an inspection to find it. But, and this is where her case fell apart, she couldn't prove definitively that the water was coming from the neighbor's property. And because of that, she couldn't prove that the HOA had violated its own rules by not taking more aggressive action. That last point was the nail in the coffin.
So with all that on the table, how did the judge actually connect the dots and make a final call?
This quote from the judge is wow. It is super telling. When he says she might have the incorrect venue and possibly party, he's basically saying she might have sued the wrong people entirely. Her real fight, he's suggesting, might have been with her neighbor directly, not with the HOA.
So the judge's logic here was actually pretty straightforward. It was like a three-step process. Step 1, Miss Abbass didn't prove the HOA actually violated any of its rules. Step 2, since the HOA only had the right to act, not an obligation, their choice not to force an inspection was totally legal. And that leads right to Step 3. Because no violation was proven, the case had to be thrown out.
And just like that, the final ruling came down. The court declared the HOA the prevailing party, and Susan Abbass's appeal was dismissed. After all that time, money, and stress, she ended up right back where she started, with a big problem and, presumably, water still leaking into her home.
So this whole case leaves us with a really big, kind of uncomfortable question that so many homeowners could face. When your HOA has the power to step in and help, but no legal duty to actually do it, what are you supposed to do? It's a stark reminder of just how important it is to know the fine print in your community's rules. Because as we just saw, the difference between a right and an obligation can change absolutely everything.